Well, it's Thursday at our law firm, and while we're not in court today, we're nevertheless very busy getting ready things for next week, where we will be on trial, a jury trial for the first time in a long time, and we're just getting ready for that. With that said, I want to talk a little bit about not going to trial and talking about pleading guilty. Obviously, there are a lot of situations where pleading guilty is the best course of action, and the question is, do you understand why you are pleading guilty? And if you don't, and you want to take back that plea, are you able to do that? And what needs to happen to do that? Well, the question is, yeah, the answer to the question is yes, you can take back the plea, but you really shouldn't put yourself in that situation, because if you do, you're making it much more difficult to take back the plea than if you just decided to go to trial. Before pleading guilty, it's very important that you review all of the discovery with your attorney, and that's witness statements, video, chemical evidence, whether it be a chemical test. If it's a homicide, obviously you want to review an autopsy. If it's something where it's alleged that you were involved in some type of illegal transaction, you want to know what your options were regarding pretrial motions to suppress evidence. All that's very important. I've done a lot of videos on probable cause, search and seizure, and I encourage you to watch those videos, read those articles. I will link a few in with this video. With that said, in New Jersey, there are two standards that the court uses, and that's if you want to withdraw a plea before sentencing and post-sentencing. It is easier to withdraw a plea if you've not been sentenced, and the standard the court will use is in the best interest of justice prior to sentencing to allow this person to withdraw the plea. If it's post-sentencing, the standard is a manifest injustice. And really, that's a much higher standard. In both situations, the burden of proof is on the defendant, otherwise known as the petitioner. And so it's up to that person through their attorney to make the argument. Now, in New Jersey, there is case law that talks about 4 factors that the court will use. And I don't go through all the factors. I'm going to put out an article later today on this. But bottom line is that just arguing that you're innocent isn't enough. The court has to be convinced that you have a colorable claim of innocence, and also use other factors, which include how, if at all, the state's going to be disadvantaged by you taking back this plea. Have witnesses, since you decided to do this, kind of disappeared? Have they died? Have they gotten sick? Are they incapacitated? In addition, what are the strengths of your case? So it's up to your attorney to argue that. Further, the court's going to look at what you knew prior to pleading guilty. What evidence did you review with your attorney? Why you're taking back that plea? Now, in a lot of situations, you're going to have a new attorney, and it's going to sound like in a lot of situations that you're making an ineffective assistance of counsel claim. That's not why you're there. You're there to take back your plea, so you want to focus on those 4 factors, which I'll talk about later in my article today. Finally, if you have questions, 215-755-9000 in Pennsylvania, in New Jersey, 856-793-7429, both numbers 24 hours a day, 7 days a week. The website, GamboneLaw.com, a tremendous resource for you and your family. I put articles out there all the time about probable cause, illegal search and seizure, traffic stops, anything involving criminal defense. It's on the site. It's a tremendous website. No other criminal defense law firm in Pennsylvania or New Jersey has anything like it, I guarantee it. So finally, again, 215-755-9000. In New Jersey, 856-793-7429, 24 hours a day, 7 days a week. I hope you're having a great Thursday, and I will talk to you all soon.